Um, My name is Mark Scherzer. I'm a two-person firm, and our concentration is in representing people with insurance difficulties. So this is what I do every day, all day, and I want to try to lay out sort of, first of all, a picture of what types of problems people with insurance problems are going to have. Then a sort of orientation to what the sources of the law are, because there are more than you might anticipate. Then suggestions about how, when you get one of these claims, you might go about gathering information to contest the denial of the claim or help someone through the denial, and then some thoughts about litigation strategy. It should come to that. I don't know if this program ever gets its volunteers into litigation.
We don't go that far.
Don't go that far. So maybe we can truncate that part depending on how time goes. And then Wendy is going to be talking about in detail some specific examples of cases that have come through the doors here that she's handling. So let me start with the types of issues you may see if someone's coming in. And I'm going to talk from this outline, but I'm not going to certainly read from it. It's a very dense outline. It's meant to be a resource for you to go back to, because it has citations to case law. There will be problems when people have insurance, and sometimes the problems are that they don't have insurance, and that's often more of a social work issue. But for the attorneys, the problems are going to be if they do have insurance, if the insurance is not helping them with the problem they have. And there are several reasons why their insurance coverage may not help them. One is that they may have something called a pre-existing condition. That is a condition they had before their coverage began. And the rules are generally that insurers can exclude coverage for a period up to a year for conditions that people had before they got the coverage, unless they had prior coverage, and there are rules about how long you can have in terms of a break between your old coverage and your new coverage in order for your prior coverage to count as prior coverage for getting through a pre-existing condition limitation period. So, and the claims may be, well, you had fibroid masses, and we think that was in fact you had breast cancer before, you had that pre-existing condition before, so we don't have to cover it now. Or you had malaise and headaches and fatigue, and we think that was actually a symptom that you had liver cancer, and we don't have to cover that. We'll talk more about the particulars of these issues as we go along. There may be issues about whether people's coverage is in effect. Suppose they went out on medical leave because they were sick, or they went out on disability, and did their medical coverage continue to be in effect while they were on leave? For how long? Did they have to do something to keep it in place, and did they fail to do it, or did the employer not give them the appropriate notice about what they had to do it? One of the types of ways to continue coverage everyone knows about is COBRA. You're going to talk about the COBRA case, right? Which is a federal law that requires that you have the right to stay on your coverage for 18 months after you leave a group, if you pay the premiums, up to 29 months if Social Security disability determines that you were disabled within 60 days after you left the group. And although federal law applies only to groups with 20 or more employees, New York state law has a rule if you're in a group as low as 2 people, as small as 2 people, you still have essentially the same COBRA rights. There may be questions about whether the person was covered because somebody wasn't paying the premiums for them, or the policy wasn't enforced because they failed to pay the premiums, or the eternal horror that there's been a divorce and the spouse tells the employer not to cover the other spouse anymore without any notice to that other spouse. And there may be issues about whether someone is properly covered by their plan. For example, were they actually eligible to be covered? Did they work the requisite 20 hours a week or 30 hours a week? Were they really an employee of the group? You will find a lot of sick people that one way they get insurance that they can afford is to get into group insurance. That's a wonderful way to get insurance if you actually are a member of a group and employed by it. But if it happens to be your Uncle Jack's hardware store and you're not really employed, but they put you down as an employee and paid the premium for you because they knew you needed the coverage. And then the insurance company audits the books and determines that, in fact, you were never reported as an employee, you never received a salary, and you certainly weren't going to work 20 hours a week. You may have a problem with, essentially, if they're claiming as fraudulent coverage on your part. So those are issues around sort of, do you have the coverage? And then within, assuming you do have the coverage, there may also be a whole series of issues about whether you get access to the treatments you want. For example, you have breast cancer, you need a mastectomy, you want to go to a breast surgeon, and your plan tells you, your health plan tells you, you don't need to go to the breast surgeon. You can go to a general surgeon who's on our list, and that's good enough. So there's an issue of whether you have access to specialty care. There's a question of whether your treatment is maybe medically necessary. Almost, insurance policies are contracts. You should read them like contracts. And when you read them, you'll see that they almost universally have a requirement that in order to be covered, your care be medically necessary. That means both that it's medical and that it's necessary. So is it medical if, for example, you have nursing care, but all the nurse is really doing is feeding you and taking you to the bathroom? Is that medical or is that custodial? Or another medical necessity issue may be you need surgery of some sort. Is it cosmetic or is it medical? For breast cancer, it's one place where the law, actually both at the federal and the state level, has been very clear, at least with respect to reconstructive surgery after mastectomy, that that's not considered cosmetic surgery, that that's something that is mandated to be covered. But that's quite unique. Quite unique. It's unique. There are lots of areas for dispute as to whether things are cosmetic or medically necessary. There may be a question about whether the treatment is experimental or not, or is it well established, because almost every policy will exclude coverage for treatment that's experimental or investigational. Oh, so you want a bone marrow transplant with high-dose chemotherapy for this particular cancer. Is it established for this cancer, or is it experimental for this cancer? Oh, you want to get low-dose chemotherapy, a newer technology, which actually has a lot of promise in some areas. Is that proven, or is it experimental? You want to take a drug that's approved for one cancer, but you want to take it for another cancer. Avastin is approved for colon cancer. It's now widely being used and acceptably for breast cancer. But suppose you have a rare cancer for which it hasn't been demonstrated yet to be effective, and may never be demonstrated to be effective because your cancer is so rare that they will never run the clinical trials on a population this small for it to be proven that it's effective. I have a case going on like that right now, which is an incredibly difficult one. Because it's an off-label use of a drug, it's a variety of experimental treatment, and the plan is saying, sorry, it's just not established, and we only have to cover established treatments. You may find that there are caps in plans or exclusions of coverage for certain treatments, and in many cases, these are perfectly legal that they exist, and they are almost impossible to get around. So you may have a client who has a $25,000 cap every year on prescription drugs, or the client may be in the Healthy New York program. This is a program that New York State decided to promote in order to show that we could get a lot of people insured. Unfortunately, the way they did it was to make the premiums cheap, and the way they made the premiums cheap was to exclude all sorts of benefits, like prescription drug benefits, or they have one variant that has a $3,000 a year cap on prescription drugs. Well, your patient with cancer may take oral medications that cost $3,000 a month. What happens when you hit that cap? That's a really tough one to get around. You may have problems because people fail to get pre-authorization that's required by the terms of their plan before they get surgery or before they go to a particular specialist. You may find that people have fights with their plans over whether they get to go to a particular specialist who's not in their network. Most health coverage in New York and most other states now is managed care coverage. It's HMO-based coverage, meaning that plans have networks of providers they contract with. If you're very fortunate, You also have something called a point of service option or something like that, which allows you to go out of the network and get some reimbursement. Many of us may have that. Many people may not be so lucky. And they may be stuck with the providers in their plan, even if the providers don't necessarily have the qualifications to treat or the experience to treat a particular rare variant of the cancer that they have or something like that. In New York, one of the most frequent disputes of this sort that we see is people who have virtually any plan other than Empire Blue Cross and get cancer and want to be treated at Memorial Sloan Kettering because it's the cancer center. And under New York law, of course, if you can show that there's not an adequate in-network provider who can treat your illness, you have the right to go out of network and have your plan pay for it. You only pay the in-network sort of cost. But I see this probably once a month, that people have decided that there's no adequate specialist in their network because the only place that they're going to get adequate treatment is at Memorial, and they want to go there. Sometimes they're right, sometimes they're not. You may have issues about coordination of benefits between plans. Many people are fortunate enough to have more than one type of coverage. One spouse has coverage and covers her husband as a dependent, and he has coverage at his job and covers his wife as a dependent. Two types of coverage. It sounds great because if one fails, maybe the other fills in, and that's often a good thing. But I have a case going right now where there are two plans, the husband's plan and the wife's plan, and each thinks the other is primary, and neither one will pay. So having, and as one court said, having more than one insurance plan is the only thing worse than having no insurance. And then there are issues sometimes if you do go out of network to get treatment, plans will pay according to what they consider to be the usual, customary, and reasonable charge for a service. And they may think that your doctor who charged $400 for the office visit was slightly above the usual, customary, and reasonable cost, and they will base their reimbursement on the usual, customary, and reasonable cost, which may mean they pay you $50 or $60 against that $400 bill. So there's a host of possible, and these are just the most common ones, there's a host of possible problems people may encounter when they have serious illness and they're using a lot of services. With disability claims, which you may also encounter, there will be many similar situations. That is, there will be similar situations about whether the person was properly on the plan, whether they properly had the coverage, whether their premiums were paid for them. There are issues about pre-existing condition limitations on disability plans as well. So if you take a job and you become disabled 2 months later, and they say, well, you had this diagnosis 6 months before, you were being treated for it in the 6 months before you got on the plan, we're not going to cover you for it. Then there are other issues about, is the person disabled? How bad off are they? And what is the definition of disability? Are they able to do their regular occupation? Hopefully, if you're all lawyers, you've got these policies, these disability policies that cover you in your regular occupation. So should you have some sort of cognitive difficulty because of an illness, and many people with chemotherapy do get tremendous cognitive difficulties that last past the chemotherapy, you would be covered for that. You would get a disability benefit if you couldn't work because of that, even though you might be able to do some other type of work which doesn't require your cognitive functions to be so high. But some people don't have that type of policy. Some people have a policy which will only cover them if they're unable to do any substantial gainful employment, more like the Social Security disability standard, and that can be very difficult. You may have to establish whether the person can in fact do the material duties of their job, and you're going to have to establish what those duties were. You may have problems from people who are coming in saying, I'm feeling a little better, I'm on disability, what kind of work can I do part-time without jeopardizing all my benefits? Do I have to report my activities to my insurance company? I think I'm being followed, and someone is taking pictures of me, and is this a social work issue? Sometimes. but sometimes they are being followed. Sometimes there is a van sitting at the end of their block with a cameraman in there, and that cameraman follows the people around to see whether, in fact, their reports of their limitations on their activities are consistent with what they're actually doing. And is that okay for the insurance company to surveil you? Yes. And there are limits, but yes. There may be issues about how benefits are computed, whether people might be able to get partial disability benefits, and what about keeping other benefits that are contingent on your being disabled? Many people who are out on disability will get continuations of health coverage and life coverage and pension accruals while they're on disability, and that's something to be aware of when people are coming in with issues about their disability coverage. There may be a host of other questions that depend on their being considered disabled and getting disability benefits. There may be a whole lot more riding on it than just the monthly amount they're getting from disability. Okay. So that's sort of an overview of what types of problems you may encounter. So let me talk about where your sources of law are. This is the driest, most horrible part of what I'm going to talk about. Because it starts off with a term that everyone hates to hear, which is ERISA. Most people who have health coverage, the vast majority of people who have health coverage, have it through their employment. In New York City, actually, it's not quite so true because a lot of people have it through public programs like Medicaid. About a quarter of the population has it through Medicaid and Medicare, the public programs, but still half of our population has private health insurance, and almost all of that is gotten through employment. And if you have coverage through your employment, unless that is meaning that your employer has established and maintains the coverage for its employees, or through a union that establishes or maintains it through its employees, and you're not working for a church or a government, those are exceptions. But if you're in that broad category of private employment, you work for Columbia University, you work for Chase Bank, you work for Joe's Hardware Store, and that's how you get your coverage. ERISA, the Employee Retirement Income Security Act of 1974, is a law that is going to have a big effect on your client's rights. It's a federal law, and it has not a lot of substance to it in terms of substantive rights about what has to be in insurance or not in insurance, but it has a whole lot of procedural rights and protections that you'll need to be aware of and which I'll discuss. If your client works for a really big firm, chances are very high that the client is going to be working for a firm that self-insures, meaning that the firm did not go out to Empire Blue Cross or Oxford or United Healthcare and say, I want to buy an insurance policy to cover my employees. Instead, they say, we've established a fund to pay the health costs of our employees. We've established the benefit package we want. We're going to hire insurance companies to administer it because they're good at taking in the claims, looking at them, deciding what to get paid, and writing a check. But we're assuming the financial risk, not the insurance company. And if that's the case, ERISA is going to be the only real set of laws that governs your client's rights, because there's no insurance policy involved there. And sometimes these self-insurers will go out and buy what they call stop-loss policies. It's sort of like a reinsurance system where once their claims get to a certain point, they can turn to a reinsurance company and say, reimburse us. That doesn't make them an insured plan. They're still considered self-insured, and ERISA is still going to be the source of law for you. If the employer actually has gone out and bought an insurance policy, and this is much more common in the small group market, under 50 employees, it's almost universal there, then there will be state laws that will also cover your client's rights. Now, this becomes an incredibly complicated issue, which I will condense into about 3 sentences or less. Some of those state laws may not apply, even though they're sitting there in state insurance law, because there's a concept that ERISA preempts state laws. that relate to employer benefit plans, except for those state laws that specifically regulate insurance. Okay? And there is more litigation than you can imagine out there. I mean, there was a case in 1994, I think it was, sorry, yeah, 94, where a Supreme Court judge noted that there were already 2,000 plus reported cases on the scope of ERISA preemption, and they were very difficult to reconcile with one another. That hasn't gotten any easier, and the cases are no less common than they were then. So you want to be aware of what state laws may apply, and you want to be aware of what state laws don't apply. For the major issues where state laws will apply, even though it's governed also by ERISA, state laws that mandate that certain benefits be provided in insurance plans are not preempted by ERISA. Those exist and can be relied on. State laws that require external review of insurance company decisions by external reviewers, and every state one has such a system, and New York has the biggest such system. Those laws are not preempted by ERISA. State laws relating to sorts of remedies you may have against your insurance company generally are deemed to be preempted by ERISA. So, for example, in those states, unlike New York, which liberally recognize punitive damages against insurance companies, ERISA preempts those state laws. You cannot get punitive damages under ERISA against an insurance company that denies a claim. Consequential damages beyond what's in the contract, no, can't get those even in a insured plan in New York or anyplace else, because that's preempted by ERISA. So you can read the case law. I'm not going to try to go through the rationale. The essential principle that it used to be there was a clear three-part test under Supreme Court precedent, but in 1999 the Supreme Court kind of moved away from that more to a pornography case, kind of we know it when we see it standard. I think the essential thing is going to be is if you can determine that a state law specifically somehow regulates insurance under the state's police power to regulate insurance, it's most likely to be something that can be enforced and ERISA will not preempt. If it's something like a punitive damage claim, which comes from broader common law principles in the state for people who breach their contracts, very likely to be preempted by ERISA. Okay. And then there are questions always like, suppose you had group coverage and you left that coverage and you converted from there to an individual policy, and you had the right to do that conversion because of the terms of the group plan. Well, are you subject to ERISA or are you not subject to ERISA? Most of the cases seem to now be coming down saying the right to convert that's in the group plan is subject to ERISA. The substantive provisions of the policy you buy after you've converted, now you have an individual relationship with the insurance company, are not going to be subject to ERISA. That's sort of an alert. Be alert that you may have state law issues if it's an insured plan, and ERISA issues. And if you have somebody who bought individual insurance from an HMO off the street in New York, not through an employer, there you're going to be solely in the state law category of coverage. And New York does require that every HMO sell a standardized product, standardized policy, which is quite comprehensive, to any individual who can show that they're a resident of the state, who's not eligible for group coverage and not eligible for Medicare. So a lot of people with serious illness who may not have a relationship with an employer buy that kind of coverage. It's not so. Even though very few people globally in New York State have that coverage, if you're dealing with people with very serious illness, there's a much higher probability they're going to walk in the door with individual coverage, and then you're going to have to deal with state law solely and not with ERISA. So let me go back and tell you what ERISA does. That's important for you to know. And I think actually it's a tremendous tool. I mean, people used to say, oh, we don't want to be subject to ERISA. People fought being subject to ERISA because they couldn't get things like punitive damages. But there's a lot ERISA gives you that you don't get under state law. And developing common law of ERISA, which I think is a lot of opportunities. So what are the principal issues you get, the principal benefits you get with ERISA? There's a requirement that there be accurate disclosure to the people who are part of an ERISA plan of the plan benefits, of the limitations, of what the obligations are of the insurance company or benefit plan, and what the individual's obligations are. They have to be given what's called a summary plan description, which sets all this out, and an identification of who's running the plan as the administrator, who has authority to make decisions about claims, where to get more information, and where to get what they call plan documents, which are more than the summary. They are the insurance policy or the trust agreement that constitute the real rules of the plan. ERISA establishes a fiduciary duty on those who run the plan to run it for the sole benefit of the plan beneficiaries, as a prudent person would, with loyalty to the plan terms and adherence to rules of fairness. So one person doesn't get a benefit under an ERISA plan that somebody else doesn't get if they're similarly situated. The employer is not required to have employee benefit plans. They can terminate them almost at will unless they've somehow contractually guaranteed that they won't do it. But if they do establish a plan, they've got to establish these rules of fairness and adhering to the rules. And that's a tremendously powerful tool on your part to use, because you can find out what the rules are and see if they followed them. So it's been held that it's a failure of it's a breach of fiduciary duty if you don't, when plan participants ask for information because they don't understand something, if you don't give them a complete, intelligible answer to the question they're asking, that can be a breach of fiduciary duty. If you don't provide a full explanation of the claim denial, why it is you've denied the claim. If you misrepresent something about the plan in order to, and the employee relies on it, that could be a breach of fiduciary duty. And failing to disclose various incentives to the participating providers has been held to be a breach of fiduciary duty. Now, problem is, in the last couple of years, the Supreme Court has cut back, and I alerted you to the Great West Life case and in 2002, and the Sereboff case more recently, on what happens if there has been a breach of fiduciary duty. At the beginning, when people first identified that, oh, we can sue for breach of fiduciary duty, they were getting all sorts of monetary damages as a result. The Supreme Court has been saying now, well, yes, you can sue for breach of fiduciary duty, but only if there's a remedy that is sort of within the tradition of equitable relief. For example, you can put constructive trusts on segregated funds. That's equitable relief. You can get reinstatement to a plan. If somebody misrepresented something about a plan and you said, oh, okay, I won't take it because I'm not going to get the benefits I really think I'm going to get, and you really could have benefited from being on that plan, you may get reinstatement. That's an equitable relief. But if you're looking for just money damages, it's going to be a problem. Third aspect of ERISA, there's a section 510 of ERISA which says that you cannot discriminate against someone in order to deprive the member of benefits to which he or she may become entitled. So, for example, employer finds out that person has cancer and decides that person is going to be really expensive. Employer decides to fire that person in order to avoid costs to the health plan. That would be a breach of ERISA section 510. Fourth element is important in ERISA. And by the way, I should say that principle may sound great and you may think it gets you really far. It only gets you a very limited distance. There was a very famous case in the early 90s in Texas in which an employer found out that an employee had AIDS. Thought this guy is going to be really expensive. Met with their insurance company. The insurance company said, well, you know what you can do? You can cancel your insurance plan. You can hire us just to do administrative services like we do, for self-insured plans. With your self-insured plan, you can eliminate some benefits. And the employer did that. The employer imposed a $5,000 cap on AIDS treatment, whereas there was a $1 million cap for any other disease. And it was pretty clear it was done in absolute response to this guy's claims, and he sued under Section 510 of ERISA. And he lost, and he went to the Fifth Circuit, and the Circuit said, well, sorry, no, it's not discrimination, because all people with AIDS are being treated equally here. And it's not depriving him of benefits to which he might have had an expectation of being entitled, because the employer could always cancel the insurance policy altogether. So what he got was gravy, essentially, and there's no claim there. The Supreme Court did not take cert on that case. The federal government briefed the Supreme Court saying you don't need to take cert because the Americans with Disabilities Act, which is going into effect in 1992, is taking care of that problem. But we have since found out, the Americans with Disabilities Act, that it didn't take care of the problem, and virtually every circuit court has held that an employer that discriminates against a disease in setting up its benefit plan is not discriminating as under either the ADA or Section 510 of ERISA. It would be a bad thing if you didn't let that person with AIDS or cancer get access to the annual checkup that everyone else gets. I mean, you can't pick out people and not give them benefits, but you can certainly eliminate the benefits that are most important to those people without being held to discriminate against them. Next item on the agenda for ERISA, though, that really helps you is that ERISA requires a full and fair internal review of denied claims. And there are extensive Department of Labor regulations about how that comes about, with time frames, with accelerated time frames for medical urgency, with a 3-day turnaround on decision making, that kind of thing. And then if you've gone through and exhausted all your internal remedies, and you must exhaust your internal remedies, ERISA gives you the right to sue in federal or state court for the benefits denied. And one thing state law in New York doesn't give you, the court has authority in ERISA to award attorney's fees. It doesn't have to be a prevailing party. There's a 5-part test. They'll look at one of the big issues always is whether you prevailed, but it's also whether you protected other people through bringing the case, what the respective resources of the parties were, how egregious the misbehavior of the offending party was, a set of factors that may give rise to attorney's fees claim. So those are really important rights under ERISA. ERISA also has COBRA rules in it, and also there are federal rules under the Health Insurance Portability and Accountability Act of 1996, which govern things like portability of benefits from one plan to the next. You don't have to go through pre-existing condition limitations. I'm not going to go through those specifics because Wendy's going to cover some of those. But you should know that ERISA has this scheme for not only making sure there's fairness, but making sure there's an enforcement mechanism and an internal procedure. If your plan is also insured under New York law, there's separate sets of rights that you should be aware of. And I'll tell you where these are in the law, and I'll just mention some of the most important ones for people with cancer. They are in Article 44, 49, and 48 of the Public Health Law, and Article 49 of the Insurance Law. And these fall generally under what we would call the Managed Care Bill of Rights, which have all sorts of rights that set up grievance procedures and utilization review when claims are denied because they're not medically necessary. There are also some really important substantive provisions for people with serious illness, including the right to a standing referral to a specialist if you're in a managed care plan, should you need repeat visits, so you don't have to go back to your primary care physician each time. The right to see a specialist out of network if there's no adequate specialist in the plan. The right to be treated as center of excellence for your disease if appropriate. The right to get coverage for emergency room care if a reasonably prudent person would have gone to the emergency room, regardless of whether you're actually admitted to the hospital. And the right to be managed by a specialist if it's appropriate. So, for example, there may be times in the course of complex illness that somebody may really, their care should reside with the specialist, not with their general family doctor, who's managing all the other doctors they're going to. And you have the right to get assigned to a specialist if appropriate. The medical director of the plan has to agree with you, but they have to have a procedure in effect to decide if they agree with you. And then if your claim is denied because the plan says it's not medically necessary, or if it's experimental or an off-label drug use, or that you're in a clinical trial, we have rules for external review in New York. After you've gone through an internal plan appeal, the state now has a system where you can file, and when they deny your appeal, they have to give you the form and tell you how to go about doing the external appeal. And this may be one of the most common things you get to do in this program. The state has 3 different agencies it has contracted with. They have expert doctors on their network, and they refer these cases out for review. And again, this can be done on an expedited basis if there's a medical urgency, with a 3-day turnaround. And believe it, it's a 3-day, not a 3 business day turnaround. You will get the call on Sunday if they got the appeal in on Thursday, giving you what the decision is. And the standards are fairly liberal in the external review program. If it's a question of medical necessity, they will look at whether the plan acted in a reasonably medically prudent manner in accordance with the patient's best interests. The external reviewers use that kind of very liberal standard. If it's in a clinical trial, and these next few things, you only get into this system if you have a life-threatening or seriously disabling condition. But if it's a clinical trial, if it's a bona fide clinical trial at a proper institution, and if there's a likelihood that the treatment will benefit you, regardless of what some other treatment might do that the plan might prefer you to get, it will be approved. If it's an experimental treatment that's not in a clinical trial, or if it's an off-label drug use, if you can show through medical evidence that the treatment the doctor is suggesting is more likely to benefit you than any standard treatment that's available to you, they will approve it. And it is possible to get these approved. But again, still you have to have medical evidence, which usually means peer-reviewed, published medical articles. You have to work very closely with the doctors on this to develop the evidence. And I just had a situation where, again, someone had a very rare cancer. There is no peer-reviewed literature on this because 50 people get this diagnosis every year. So it went to a panel of 3 external reviewers. One said you should cover it. One said you should not cover it because the evidence isn't there. The one in the middle, and this was so painful, said, this is not unreasonable treatment, but it doesn't meet the standard of medical literature showing that it's more likely to benefit. I've been spending a lot of time in Albany now actually trying to get a rare disease exception built into the statute and passed in the next few weeks so this person can benefit from it. The law has some tweaking it needs to undergo, but it's still a very good system. And about half the time in external review, plans are overturned. And I think its benefits are even more than that, because knowing that there's the external review system, a lot of plans will internally overturn their decisions, knowing what's likely to happen if it goes to external review. One critically important thing you need to know about external review is that you have a 45-day window from when you get the first appeal, the first final determination from the plan to go into external review. Very often plans will offer you a second level of review going up to the board of directors of the plan. You can take that, but if you just rely on that, you will have missed your deadline very likely for going to the external system. What I typically do is do them simultaneously. I send a letter, I do the external review, and I send a copy of it to the plan saying, treat this as the internal review. That way so nobody can say we didn't exhaust all our remedies, but it's a very good system on the whole. And the insurance department, for all the faults people find with it in other ways, does a wonderful job of running that system. They're really quite dedicated to it. I'm running really a little short on time already, so let me just, in the materials there's an alert to a consumer's guide to the managed care bill of rights in New York. I recommend it highly. It's a very good summary, and I think it's written for lay people, so even we can understand it as lawyers. And I just want to also then talk a little bit about the procedure you use to contest these claims. Because ERISA gives you these rights to full and fair review, and you look at these regs, they are great. Usually you'll have a 180-day period in which to appeal a denial of a claim. But what's important is that two things. One is that you have tremendous access, if the plan cooperates, to get information about the claim denial. Plans have to give you all documents in their possession pertinent to the claim denial. That's a very broad standard. They also have to give you, of course, the plan documents themselves, the rules. They have to give you the clinical rationale for why they deny the claim. They have to give you the criteria they use, if they have special criteria. And plans have books of these criteria saying, you know, yes, we recognize the use of Avastin for XYZ and not for ABC. And that will be often in written criteria that they have to provide to you. But you can basically get almost all the claim file, including internal emails. And you should make a demand for that information right away when the person comes into you, so you can use the information to do your appeal. And we've included in the materials a sample demand letter for that kind of information. And then when you're doing the claim, the appeal of the claim denial, this is where your lawyer training comes in really handy. You know, first you're going to look at the plan documents. You're going to see what the rules are. You're going to see what they said in the summary plan description and what it says in the underlying contract, and make sure you know all the rules that apply. And then you're going to tell the plan why its decision was not conforming with that plan. And to do that, you're going to put in every bit of information that you can come up with, like you're litigating. You treat this as essentially a summary judgment motion. And there's one reason to do it is that you're more likely to win if you have effective evidence. The other reason to do it is that under ERISA, the federal courts have said that we do not look beyond what is in the administrative record that the plan considered unless you can show good cause for going beyond it. And you don't want to have to go show good cause for getting new information in later on, because you may not be able to. If that information was available to you, it may be that it had to be in your appeal, and they will not look to items that are not in your appeal when a court later on reviews the case. So you need to be comprehensive. You need to get letters from the doctors. You need to get, if it's a disability issue and the question is how functional the person is, you're going to need to get maybe statements from witnesses who are like employers or people who live with that person about what their level of functionality is. You may need to get statements from a vocational expert. If it's a question of treatment access, you may want to get not only the treating doctor, but renowned experts in the field, expert witnesses essentially to put in statements. You're going to need all that, and you're going to put it together. And you're going to either show that the plan was wrong, but it's even better if you can show that the plan's decision was arbitrary and capricious. And the reason for this is that if you look in the language of most of these benefit plans now, the plan administrators are given discretion to make determinations about benefits and to interpret plan terms. And if the proper magic words are in there, the courts have said, and the Second Circuit is particularly strict on this, so here you are in New York, keep it in mind, that they will only overturn plan decisions if they are shown to be arbitrary and capricious. The court might have preferred a different result, it might have come up with a different result on the evidence, but if you can get enough in there on the plan's part to show that it was justifiable, to show that there was something to justify their decision, and sometimes, particularly in the disability cases, it's the credibility of your client. They made a judgment about your client's credibility because your client didn't tell them that your client was engaged in some activity or other. And that justifies their overlooking anything else the client ever said, and it's very hard to overturn their decision if you can't show that they were arbitrary and capricious. So treat it like a litigation in that sense. The nice sense is that, well, it's both good and bad. There's no judge there who's impartial. to determine the claim, but someone different from the person who made the initial claim decision will determine the claim. And if you make an effective presentation, it can be effective in getting your client benefits. We're at time, so I will rely on the outline for all the other information or questions later you may have. But I think Wendy will fill in a lot of the gaps as to what we might be able to do.
We're going to take a break now, 10 minutes, 10, 15 minutes, and then we'll come back again.
Good evening. My presentation focuses on the practical aspects of the Cancer Advocacy Project cases. And most of the cases I've handled involve denials of health insurance coverage, as well as denials of disability benefits. I first became involved with this project almost 10 years ago when I attended a training session very much like this one. Soon after, I was assigned a client with recurrent breast cancer. She had been treated previously with surgery and chemotherapy, but the cancer recurred. And as a parenthetical, nowadays there are pharmaceutical agents on the market to prevent or lower the recurrence of breast cancer, like Herceptin. But in those days, which was not so long ago, there were no such drugs. Her physician recommended a bone marrow transplant, and this was her last treatment option. Her insurance carrier, Empire Blue Cross Blue Shield, had denied coverage of the bone marrow transplant, stating that it was an experimental investigational treatment. So the client was facing a life-threatening situation if I couldn't get the situation reversed. And I thought, what have I gotten myself into? Well, we met and she gave me all of her medical records, including her hospital records. When I reviewed them, I noticed a lot of mistakes, things like clerical errors and partially paid claims. I drafted a letter to Blue Cross indicating that we would be challenging the denial of the bone marrow transplant, but meanwhile, could the company clarify some of the discrepancies in the records? Not long afterwards, Blue Cross responded, saying that the case had been reviewed again, the denial was being reversed, and the bone marrow transplant would be approved. Now, I don't want to make it seem as if this process is too simple, but as this case demonstrates, there is at least a willingness on the part of healthcare insurers to take a second look if the denial decision is challenged. And in any event, the result here was very exciting, and I learned some lessons from this case as well as some others I've handled for this project that have culminated in successful resolutions. So let me share some of these strategies with you. First, all carriers in New York are required by New York State insurance law to have procedures in place for handling complaints and grievances. In my experience, the most established companies follow these procedures, meet deadlines for responding, etc. You should do so as well. Get the insurer all the medical information necessary for your case and meet all the deadlines. Second, focus on the reason for the denial of coverage. Was it an investigational experimental denial, a lack of medical necessity denial? Is the company invoking the pre-existing condition exclusion, or denying a claim because the patient saw an out-of-network physician? The reason for the denial will dictate how you craft your arguments. Third, review the documentation thoroughly. That would include the healthcare plan or disability policy, medical records and claim forms, and any correspondence from the carrier. For medical necessity claims, insurers are now required to disclose the specific medical findings relied upon when rendering a denial decision. Fourth, enlist medical support. Often the physician is eager to put his or her recommendation in writing. Physicians are also an excellent source for peer-reviewed medical literature. Fifth, review all the medical records and claim forms for mistakes. Errors are rampant. Next, get an attorney authorization form from the client. Under HIPAA privacy rules, the insurance company will not discuss the case with you without patient permission. And I've included a sample of attorney authorization in the materials. Persevere. If you're filing an internal appeal with the insurer and don't receive a response in the requisite time frame, pursue it. under a 2001 settlement agreement between the New York State Attorney General's office and 6 major HMOs, failure to meet statutory deadlines for processing an appeal results in an automatic reversal of the denial decision. And finally, I'll mention the CAP panel. If you encounter a problem, you can email the panel, and invariably someone will offer helpful suggestions. So the first cases I'll discuss concern a denial of coverage based on a pre-existing condition exclusion. And according to New York State insurance law, a pre-existing condition is a condition for which medical advice, diagnosis, care, or treatment was recommended and or received in the 6 months before coverage or enrollment in a health plan. The 6-month period is the look-back period that the health insurance company will rely upon to determine if a pre-existing exclusion applies. HIPAA limits the duration of the pre-existing condition exclusion to no more than 12 months. I think it's sometimes 18 months in cases of late enrollees, but the 12-month exclusion is reduced by one's prior continuous creditable coverage, which in New York is defined as coverage uninterrupted by a break of no more than 63 days. Pre-existing condition disputes with a healthcare insurer are categorized as grievances. Another common type of grievance is difficulty getting referred to a specialist. In New York, managed care companies must have a procedure in place for responding to these grievances. Grievances are addressed by the insurer. And I think Mark mentioned you have 180 days from the date the insurance company notifies you of a pre-existing condition exclusion to file a grievance. The insurer must evaluate the grievance within 30 days of receipt of the grievance letter and provide a written response within 45 days. Statistics compiled by the New York State Insurance Department for 2005, that's the most recent year for which the figures are available, show that grievances filed with health insurance companies by members had a 47% reversal rate. Now, that includes all grievances, not just pre-existing condition exclusions, but it does indicate a degree of receptiveness to these claims. And just as a few examples, in 2001, Oxford had approximately 6,600 grievances filed, 3,194 were upheld, 3,678 were reversed, reversal rate of 54%. Also in 2005, GHI Select HMO had 683 grievances filed, 239 were upheld, 429 were reversed, reversal rate of 64%. Finally, Empire Health Choice had 641 grievances filed that year, 501 were upheld, 114 reversed, a reversal rate of 18%. But again, on average, the reversal rate is 47%. And I'm going to talk about 2 pre-existing condition cases. In the first, the client had a history of sporadic health care coverage. She was originally diagnosed with head and neck cancer in 2001 when she was covered by a health care plan. She had surgery and chemotherapy and went into remission. All of her medical costs were covered. Then, in 2004, she voluntarily canceled her insurance and went there for a period of time. In January of 2005, she re-enrolled in an Empire Blue Cross HMO PLS plan. The cancer recurred, and she was treated in February of 2005. She was then sent a notice by Blue Cross saying that approximately $7,500 of one particular claim was being denied based on a pre-existing condition exclusion. We sent a grievance letter to Blue Cross raising 3 points: that the client had received no diagnosis or treatment, nor had any diagnosis or treatment been recommended by a physician in the 6 months prior to the effective date. That Blue Cross had represented to the client in a phone conversation that no pre-existing condition exclusion would apply. And we also pointed out some inconsistencies in the Blue Cross claim statement. For example, partial payment had been made for some elements of the claim, pathology report, but other elements were not covered. Within a few weeks, we received a letter from Blue Cross saying that not only would the company cover the claim we had submitted, but additionally, the company had reviewed the entire case for all claims denied as a result of a pre-existing condition exclusion, and, quote, based on our review, the pre-existing denial will be bypassed on all these services, unquote. And this letter is also contained in the materials. There was no explanation of why Blue Cross had reversed. Moreover, instead of just reversing the particular claim we had submitted, the company listed 5 other claims for which the pre-existing denial would be bypassed. The grievance had been for a claim of approximately $7,500. Blue Cross was now exempting approximately $25,000 from the pre-existing condition exclusion. So this was a very nice result, and I think exemplifies the tendency I referred to earlier, that the insurer will reevaluate its decision of if the denial is challenged. And here, as I mentioned, Blue Cross went beyond the individual claim we had disputed and reanalyzed its pre-existing condition determination for the entire case. My second example of a pre-existing condition case is somewhat more problematic, but it's worth discussing because it illustrates some of the pitfalls that can occur when the proper procedure is not followed. Now, this client had gone to a physician in December of 2002 when she was covered by a group plan, and the doctor found a suspicious lump. The lump was biopsied but not removed, determined to be benign, and the client was given a diagnosis of fibrocystic disease. This is not breast cancer. The client continued to maintain her health coverage, but in early 2004, she let her policy lapse because she and her husband were starting a new business and they would be enrolling in a new plan. During the time when she was not covered, in March of 2004, she visited a doctor because she had the flu. At the end of the visit, she mentioned the benign cyst and said she wanted to have it removed because it was chafing her clothing. The doctor did not examine the lump, nor did he perform any diagnostic tests, but he did record the conversation in the medical notes and referred her to a surgeon. This very brief notation in the medical notes would come back to haunt her. In July of 2004, the client's new health insurance became effective, so there was a gap of approximately 4 months when she had gone without coverage. Her new insurance company was Atlantis Healthcare. In August, about a month after the new insurance became effective, she went to a physician, mentioned the lump, a biopsy was performed, and in early September, she was diagnosed with breast cancer. She subsequently had a lumpectomy and chemotherapy. Her treatment was pre-approved for coverage, but in late of October of 2004, Atlantis sent her a letter saying that the treatment would not be covered based on pre-existing condition exclusion. And they specifically cited the notes from the doctor's visit in March of 2004. Now, ordinarily, one would have the 180 days from the date of denial of coverage to file a grievance with the health insurance company. In this case, that would have been the end of April of 2005. But instead, as many people do, this client tried to forget about it. And only when she started receiving the invoices for payment, approximately $30,000, did she take action. She and her husband went to see their city councilman because they were very active in local politics, and he made a direct complaint against Atlantis Healthcare to the New York State Insurance Department. This was done in August of 2005, 4 months after the time to file a grievance with the company had expired. To make matters worse, the councilman wrote a very ineffectual letter of about 1 paragraph that basically said, this woman is my constituent, Atlantis Healthcare gave her a hard time, please help her. And the insurance department wrote back and essentially upheld the right of Atlantis to impose a pre-existing condition exclusion. Finally, in October of 2005, she was referred to the CAP program. I put together another grievance letter for her. I gathered some medical evidence as well as some legal authority to bolster the case. Specifically, I cited a 7th Circuit case Pitcher v. Principal Mutual Life, in which the court held that a previous history of fibrocystic disease does not trigger the pre-existing condition exclusion when breast cancer is diagnosed later after a policy is in effect. I also cited the Lawson case, that's a 2002 Third Circuit case, which held that if the pre-existing condition language of the policy is susceptible to more than one interpretation, the language should be construed in favor of the patient. And the phrasing of the pre-existing condition provision in the Atlantis policy was somewhat ambiguous. In addition, I raised some objections to Atlantis's grievance procedure. Notably, the company did not have a board-certified oncologist on its grievance committee, and the Atlantis CEO and other corporate officers served on the grievance committee, suggesting a clear conflict of interest. But these kinds of substantive objections generally carry more weight with medical necessity complaints, which focus on the medical issues of the case, and I'll discuss one a bit later, not with grievances, which address more procedural concerns such as when did my coverage begin and what services am I entitled to. Moreover, the fact that the time to file the grievance with Atlantis, that 100-day period, had long since expired, did not help this case. We managed to get the New York State Insurance Department to take a second look, but at the end of that review, the department concluded that Atlantis was entitled to invoke the pre-existing condition exclusion. Ultimately, a public interest law firm agreed to work with this client and is attempting to negotiate a settlement with Atlantis that would result in a reduction of some of the charges. I'm convinced, however, that if the grievance had been filed with Atlantis within the proper time frame, and if the medical and legal arguments had been raised at that time, there would have been a better, a better outcome. And some of the background documentation on this case is in the materials. The next genre of case I'll address involves a denial of coverage based on lack of medical necessity, which is sometimes phrased as not medically necessary because investigational or experimental. And objections to this kind of denial are complaints as opposed to grievances and are appealed directly to the insurer for an internal review. If that's not successful, Mark was speaking about this, the case may then be appealed to the New York State Insurance Department for an external review. When the insurer receives a medical necessity complaint, it is required to consider specific clinical factors as well as a medical assessment of the individual's case. Despite these guidelines, which are contained in the New York State Utilization Review Law, complaints about how healthcare insurers make medical necessity decisions persist. And the New York State Attorney General's office has cited the lack of a uniform definition of medical necessity in the insurance law as the primary reason. Consequently, each plan and each insurer devises its own definition. To give you a flavor of the components of the medical necessity definition, the AMA has a model managed care contract, and Section 1.9 of that contract defines medical necessity as what a prudent physician would provide a patient to prevent, diagnose, or treat an illness, disease, injury, or condition in accordance with generally accepted medical practice. This definition isolates just two factors, the physician's judgment and generally accepted medical practice. In contrast, health insurance company definitions tend to contain additional elements. As an illustration, Cigna Healthcare defines medical necessity as including clinical judgment and accepted medical standards, but adds that the services should not be more costly than an alternative treatment which is at least as likely to produce an equivalent result. So cost becomes a factor in the utilization review performed by the insurance company. And with challenges to medical necessity denials, you should include a great deal of medical data, studies, case reports, and the like. If possible, cite articles relating to double-blind controlled studies or case reports published in peer-reviewed journals, such as the New England Journal of Medicine, JAMA, and The Lancet, or in specialty journals in the field of oncology, your fundamental argument is that the disputed medical test, procedure, or protocol is more medically efficacious and, in the long run, more cost-effective than the alternative. Several medical necessity issues that have been the subject of litigation involving cancer patients include bone marrow transplant for advanced breast cancer, high-dose chemotherapy with stem cell rescue in a variety of cancers, and finally the case I'll be discussing in a minute, CAT scan versus PET scan for a diagnosis and treatment in ovarian cancer. In New York, the procedure for dealing with a medical necessity denial, as we said, involves two levels of appeal. First, the internal appeal, when you're asking the insurer to reconsider its refusal to pay for the medical service or treatment. If the internal appeal is unsuccessful, you have the right to go to the external appeal with the insurance department. The internal appeal, you have 180 days from the date of denial to file the appeal. The insurer will generally issue a decision within 15 calendar days. You can ask for an expedited appeal, and a decision will be made within 72 hours. Your expedited appeal with the insurance department must be, as I think Mark mentioned this, within 45 days of the denial of the internal appeal. And the state will also perform an expedited appeal if the situation is life-threatening. Some statistics from the New York State Insurance Department on medical necessity complaints compiled in 2005 indicate a reversal rate for internal appeals to HMOs of 38%. For internal appeals to commercial insurers, the reversal rate is somewhat lower, about 22%. For the external appeals to the state insurance department, the reversal rate is 44%. So combined, that's a 65% reversal rate if both internal and external appeals are considered, and that's not bad. One of the medical necessity cases I handled involved a client with ovarian cancer who had received the standard treatment and did well for a period of time. Subsequently, she began to experience discomfort similar to the discomfort she had experienced when she was first diagnosed. Although her physician ordered blood tests and a CAT scan to image the area, all the test results came back negative. But he suspected a recurrence and wanted to visualize the cancer, so he recommended a PET scan. And by way of background, CAT scans are very good for showing morphology, that's more the broad shape of tumors and solid masses, whereas PET scans are a form of molecular imaging that can pick up very subtle areas of abnormal metabolic activity. And the client had an Empire Blue Cross PPO policy, and the doctor put through a request for a tumor imaging PET scan. And Blue Cross uses a company called National Imaging Associates, NIA, to do its radiological imaging. The doctor received pre-certification for the PET scan, and the client was scheduled for the test. But 2 days later, the doctor received a letter from NIA saying that the procedure would not be approved because it was not medically necessary and did not comply with Empire or NIA's clinical guidelines. NIA suggested conventional imaging, i.e. a CAT scan, but we know that had not worked with this patient. The letter from NIA also said that free copies of the clinical guidelines would be provided on request and outline the usual parameters for taking an appeal. I began by looking at NIA's clinical guidelines, and the company has a website on which it proclaims that NIA is, quote, the nation's clear leader in radiology benefits management, unquote. Voluminous guidelines are listed with about 20 pages devoted to PET scan imaging. The guidelines discuss PET scans for cardiac conditions, Alzheimer's disease, and all sorts of tumors, including head and neck, lymphoma, melanoma, colon cancer, lung cancer, thyroid cancer, breast cancer. But significantly, there were no guidelines for PET scans in ovarian cancer. So the argument became, how can you say a procedure is not medically necessary when it's not even addressed in the company's clinical guidelines? The physician was also very involved in this appeal, He prepared a statement on the benefits that would be obtained from a PET scan, and he provided references to peer-reviewed medical literature, some of which was very recent, that reported on the advantages of PET scans versus CAT scans for recurrences of ovarian cancer. And specifically, he cited several case report articles from the Journal of Gynecologic Surgery, and they were from 2004. That journal is apparently the gold standard in its field. Using all this information, I drafted the appeal letter, which was sent to both Empire and NIA, and we also requested an expedited review. Within 72 hours, we received a letter on Empire letterhead, but signed by the Chief Medical Officer for NIA, saying that, quote, it has been determined to approve the tumor imaging PET scan. Obviously, the client was very happy. But she said to me, guess what? When I need another PET scan in a few months, they'll deny it again. And sure enough, about 3 months later, the doctor recommended another PET scan, and it was denied. This time, NIA said the PET scan was not scientific, not medically necessary because the usefulness beyond conventional imaging had not been established, and because it was an experimental investigational procedure. So we sent another internal appeal letter. I reiterated all of my earlier arguments, adding same patient, same physician, same procedure, same medical condition, and you just reversed your denial and approved a PET scan 3 months ago. I also wanted to know why the procedure was now being labeled experimental investigational when it had not been so labeled before, and I again referred to the NIA clinical guidelines, which had not changed in the 4-month period since the first appeal, and still did not include references to ovarian cancer. As before, we requested an expedited appeal. Well, we didn't hear anything for a week or so. Finally, I contacted Empire. They conceded that they had misplaced the appeal letter, but agreed to accept another copy by fax. Within 2 days, we received a response stating, quote, the medical director, a board-certified eligible physician with a specialty in oncology, has reviewed the information. We have determined that the service for a PET scan is medically necessary. After this misplaced appeal incident, I had conversations with some supervisors at Blue Cross, and a notation was made that future PET scans would be covered for this client. And although we ultimately prevailed in our efforts to reverse all the denial decisions, this case was very frustrating because of Blue Cross's pattern of rejecting the claims when they were first submitted. In the end, I'm convinced that the medical evidence submitted from a highly reputable journal was pivotal in causing the insurer to finally approve the PET scan. Now, the events of this case occurred between August of 2005 and May of 2006, and there is an interesting addendum. A few weeks ago, Laura Mosiello, the director of the CAP program, sent notice to the panel of an ovarian cancer patient who had received a medical necessity denial for a PET scan. The only difference between this new case and the case I've just discussed is that the new client has refractory cancer. That means that it is not a recurrent. She's still struggling with her first episode of the illness. And surprise, the insurer in the new case is Blue Cross, and the imaging company is NIA. And I got assigned to the new case and was very curious to read the denial letter, which states, per our coverage guidelines, use of a PET scan is for localization of recurrent ovarian cancer, not refractory ovarian cancer, when CAT scan imaging is negative. So what's interesting about this statement, of course, is that it sounds as if Blue Cross and NIA have now supplemented their clinical guidelines to cover PET scans for recurrent ovarian cancer, although not yet the refractory ovarian cancer. Evidently, these appeals can work, and over time, you do begin to see these kinds of changes in the coverage decisions and in the clinical guidelines of the companies, based, I believe, in part on some of the successful appeals of programs like this CAP project. cases I'd like to discuss fall into a kind of hybrid category. And the first case involved a 26-year-old woman. She had been a preschool teacher, and during that time had been covered by the school's group plan, Cigna Healthcare. She left her job. She received COBRA benefits, but didn't realize that they were COBRA benefits and believed that she was still in the group plan. Evidently, her parents had been paying the COBRA premiums for her. And this is an example of a young person relatively new to the job market who, despite being very well educated, she had a master's degree, was simply unaware of COBRA or HIPAA or any of the statutes that are so common to us. So be mindful that even very highly educated people don't know about the complexities of healthcare coverage. In any event, this client was diagnosed and successfully treated for ovarian cancer during the time that she was on COBRA. For this person, particularly because she was so young, and now, with her history of cancer, did have a pre-existing medical condition, continuous creditable coverage with no more than a 63-day gap would be crucial in order to avoid the pre-existing condition exclusion issue in the future. Now, COBRA benefits generally last for 18 months, and at the end of the 18-month period, the administrator, the plan administrator, must provide notice that COBRA is ending and verification of the effective dates of coverage. This verification is the certificate of credible coverage. In this case, it turned out that the COBRA benefits ended on October 31st, but the plan administrator had not provided the requisite notice nor sent the certificate of creditable coverage. We finally obtained verification from Cigna that the coverage had ended on October 31st, but did not receive written notice of this until December 10. Effectively, that meant that we had to get the client enrolled in a new insurance plan by January 1st to avoid the 63-day gap and the pre-existing condition exclusion issue. And we were able to find a good program for her, although based on what Mark was saying, maybe it's not such a good program. Healthy New York, which is a relatively low-cost health insurance for people with modest incomes. The program is administered by most of the major HMOs, including Cigna. We ultimately got Cigna to accept her in the plan, provided we could submit all the paperwork by December 27th. Now, this client had had a series of low-paying freelance jobs in the immediate prior years and had not filed income tax returns, the point being that she had very scant documentation. To make matters worse, this was 2 years ago when there was a transit strike in New York, so she couldn't get uptown to get the paperwork from one of her employers, and it looked as if we weren't going to make the deadline. But I finally got a Cigna representative on the phone who agreed to extend the application deadline and enroll the patient for the January 1st effective date if we could get her material, if we could get her the material overnight. We met this deadline and the client was accepted for coverage effective January 1st, so she will not have that 63-day gap. And this case is really an example of meeting deadlines and getting the paperwork in on time. The client contacted me several months later and told me that she had gone to her oncologist, used her Healthy New York insurance, and that all of her medical care had been covered. And the last case I'll discuss concerns a long-term disability policy and involves the application of both the pre-existing condition exclusion and eligibility clauses under the policy. The client was a breast cancer patient who was a registered nurse at a prominent New York City hospital. She had been successfully treated for breast cancer and was receiving chemotherapy and medication to prevent a recurrence. Although chemo is not as onerous as it once was, it remains highly depleting. So this client was going to rely on her long-term disability policy during her recovery. The insurance carrier, by the way, was Uniprominent. In mid-August of 2005, the client received notification that Unum had received her claim and was performing an evaluation as well as a pre-existing condition review. By November of '05, Unum wrote that it was pleased to inform the client that we have approved your request for benefits. She began receiving benefit checks shortly thereafter. But in early January of '06, Unum wrote, "We regret that we are unable to continue your long-term disability benefits." The explanation was that the claim had been incorrectly assigned to the employer's prior policy, which terminated in 2000, and that anyone hired after 2000 was subject to the new policy. So the first thing I did was get copies of the two long-term disability policies to compare them, and I discovered that although the pre-existing condition exclusion clause hadn't changed, the eligibility clause had, meaning that under the old policy, nurses were eligible for long-term disability coverage 1 month after hire date. In contrast, under the new policy, the eligibility period was 3 months, and this affected the pre-existing condition exclusion, which, under both policies, had a 3-month look-back period. So dates were of critical importance in this case. The client had been hired in November of '04 and diagnosed with breast cancer in January of '05. Under the old policy, she would have become eligible for her long-term disability coverage as of December of '04, and the look-back period would have been September to November of '04, well before the cancer diagnosis. On the other hand, if the new policy applied, she wouldn't have been eligible for coverage until February of '04, and the look-back period would have included January '05, when she was diagnosed with breast cancer. So it became essential to fit her into the regime of the old policy in order not to trigger a pre-existing condition exclusion. And one of the interesting facets of this case was the flip-flop of the insurer on the coverage issue. The fact that the company had initially performed an evaluation, including a pre-existing condition review, and given written approval for benefits, paid the benefits for 2 months and only then reversed, was both uncharacteristic and telling. I was curious about why the company had made such a glaring mistake in the first place and why it had not been promptly corrected. Well, the client told me that her union representative at the Nurses Association was the one who first alerted her to long-term disability benefits. We spoke to the union rep and learned that pursuant to the collective bargaining agreement with the Nurses Association, Unum's 1-month eligibility provisions remained intact for nurses, regardless of whether a new long-term disability policy was instituted. So several letters were exchanged with Unum, and I had several conversations with the senior benefits specialist. The company finally conceded that the 1-month eligibility clause would apply. Excuse me. Unum then notified us that it has come to our attention that when the new policy was written, there was an oversight concerning nurses, and that even under the new policy, nurses become eligible for long-term disability coverage beginning the first of the month following date of hire. Although Unum did another pre-existing condition evaluation, the look-back period was prior to the client's diagnosis, and she again began receiving her benefits. The lesson of this case is to analyze the seminal documents very carefully and be very proactive with the insurer, particularly if the insurer flip-flops on a coverage issue. And I'd like to briefly talk about some non-legal issues that arise in these cases. As we know, cancer is an equal opportunity disease, striking people of all backgrounds, ethnicities, religions, socioeconomic group, educational level. It's estimated that 1 in 4 Americans will have a cancer diagnosis sometime during his or her lifetime. No family is immune, and probably almost everyone in this audience has been affected. Despite its unfortunate commonality, cancer still evokes a great deal of shame and embarrassment, as well as fear. Even though much progress has been made, far too many people still do not survive. I recently learned that a client whose case I discussed tonight passed away last month. But there is an additional overlay, certainly in the cases involving health care insurance, because the very system that's supposed to help you when you're sick, the healthcare system, is now betraying you by rejecting your claims and refusing to cover essential diagnostic tests or treatment. Not infrequently, the client's survival depends on the test or treatment. And beyond the frustration of dealing with the insurance company concerning medical issues, the client may also confront astronomical financial charges that the insurer refuses to pay. So, as a result, these clients tend to harbor feelings of anger and betrayal towards the healthcare system, or conversely, extreme helplessness because the situation seems overwhelming. So how does this emotional turmoil manifest itself in your representation of a client going through this experience? I'll offer 3 guidelines. First, be cognizant of the strong emotions implicit in the situation. This disease, even for those in remission, always looms in the background. In practical terms, that means many clients will tell you very difficult and painful anecdotes about their illness. One of the clients I discussed tonight told me about how her mother, sister, and almost every female relative in her family had breast cancer, how she had dreaded getting it too because she knew it was inevitable. Another client told me about a long estrangement she had endured with her son, which continued even after her diagnosis and a later recurrence of her illness. In another context and with another type of client, one might try to steer the conversation away from those subjects. But in this situation, it can be helpful to show a little more forbearance and patience and to genuinely listen. Second, you must ascertain accurate information in order to perform your job. This includes getting a sufficient grasp of the medical situation and the documentation relating to the claim. Very often the client will not divulge the full story or doesn't give you all the paperwork. You need to emphasize how important the documentation is for presenting the best case. One client I referred to earlier didn't give me all of her denial letters until after I got one of the claims approved. She then showed up with a new stack of denial letters as well as dunning letters from a collection agency. And I think it took her a while to be convinced I was actually going to try to help her. As another illustration, the client I spoke about who went to the city councilman was ultimately very embarrassed by this, and it took a long time to get a full explanation of why she simply hadn't filed her appeal within that 6-month period. Well, she confessed that she had avoided dealing with the issue because she was terrified that the medical bills would force her family into bankruptcy just at a time when her family was embarking on a new business and that she would be blamed. The bottom line is to press for as much information and documentation as possible before you begin preparing the appeal, because you will encounter more obstacles and resistance with these clients than with others. Third, keep the client apprised of your progress. Often these clients are either very impatient with the process, or they will portray a kind of helplessness, an almost childlike sense of defeat. To overcome these situations, again, keep the client apprised and enlist their support. In one of the cases I discussed, when I explained the importance of getting the paperwork necessary for enrollment to avoid that 63-day gap, the client suddenly became energized and got her documents in order. In the disability case, we were stonewalled when we asked the insurer for a copy of the old disability policy. The client became her own best advocate, went to the Nurses Association and obtained a copy of the policy. In the medical necessity case I referred to, the client played an active role in encouraging her physician to draft a letter listing pertinent medical references. In effect, to dispel some of the impatience or helplessness you may encounter, persuade the client to work with you to achieve the most successful outcome. And finally, just a few concluding thoughts about why you should participate in this program. This is a very gratifying project. You will be helping someone who, at the very least, has been through a serious health crisis and in some cases is facing a life or death situation. So it's especially rewarding when you get a successful result. I've also tried to convey that these cases are doable. There's a lot of basic contract work, analysis of documents, persistence, phone work, tasks at which most attorneys excel. And you don't need years of experience in insurance or disability law to be successful. That's a disclaimer to go back. Finally, the CAP panel is there for you if you encounter a problem. Approximately 25 attorneys serve on the panel, from those working at large corporate firms to solo practitioners to public interest attorneys. If you run into a challenging situation, you can send a group email, and almost always some good advice will follow. So I hope the cases that I've discussed have provided some enlightenment on the process, and I do encourage you to participate in this very worthwhile project. Thank you.
Okay, before we move over to the employment piece, does anyone have any questions for Wendy and Mark?
I didn't understand. Do you have to have an unfavorable internal review in hand before you can file for an external review?
Yes, if you file an external review without that, they will
Okay.
hold it in abeyance.
So it's like an exhaustion of administrative records?
Yes. Yeah, but just that, you have to have the first one and not no more than that. First unfavorable review,
As distinct from?
a second level review. Don't, the first time you get an unfavorable review from the insurance company, that's when you go to external.
In other words, some internal review structures have more than one level.
They're permitted to have several levels.
Okay. What you just
You've mentioned several instances where there's been an okay for a procedure and then a denial shortly thereafter. The company is not held to its first decision, and why?
I think, I'll just say that's the pre-certification. So I don't want to mislead you that that's an actual approval. It's a pre-certification, and maybe more
Well, that's actually sort of a hot issue because very frequently insurance companies do issue approvals and then they later on say, well, that was only certifying that there's coverage, but we really weren't approving this particular procedure. There are medical groups that are trying to get New York law changed that the insurance companies cannot go back on their initial approvals now. But for purposes of challenging a denial, certainly when an insurance company without any distinguishing factor changes its decision, that is a hallmark of arbitrary and capricious decision-making, and that certainly helps you in the ERISA review process. If you can show that they were not basing their decision on substantial evidence, or they were not adhering to the terms of their plan or trying to insert new terms in their plan, or if they're being inconsistent in their decision-making. That's one of the great hallmarks of arbitrary and capricious decision-making, and gets you at least an overturn, maybe a remand to the plan, depending on circumstances, to decide it again, or from a court, or just a reversal by the court itself if you have to sue. But yeah, I mean, it's great evidence when they do that on your part. When they're not bound, but they're put in the position of having to explain how it came out one time one way and another time another way. So.
For medical necessity cases, besides the client's physician and the journals that you mentioned, what other sources of proof do you have to prove medical necessity, and how do you get those sources?
Well, it depends on what the issue is, but certainly the client's own statements may be important. I mean, I've had a number of cases recently for people with HIV. I'm sure there are comparable situations in cancer where people who are taking drugs that cause sort of medical deformities want surgery to remove those deformities, like Buffalo Hump from these HIV drugs. If the client is having psychological difficulties, statement from the client or from the client's companions or family members may be important in demonstrating that. It's going to come down to the facts of the particular situation, what evidence is relevant and what not. I mean, without a doctor, you have a real problem on a medical necessity claim, but there may be additional factors that you can bring in and facts you can bring in.
A lot of what you're talking about sounds like Article 78 type stuff. Is that jurisprudence going to apply? Like the substantial evidence?
Yeah, it's an administrative, it's a review of an administrative decision, so in that sense, it is like Article 78.
I'm informally helping somebody dealing with her insurance company. She's had a third recurrence of cancer. She was advised to get a PET scan at Memorial Sloan Kettering. She has gone there, she submitted the paperwork to them through the process, the screening process. They approved that. Now, she was advised to get the PET scan there. They're denying that as an approved facility. Is there anything, and I also have to adapt this to New Jersey because she's in New Jersey. Is there anything that you know related to the Guardian Insurance Company in this regard?
No, but analogizing to New York law, I would say that in order to get, if it's an out-of-network facility and the service is available in-network, you would have to, under New York law, make a demonstration that there was something inadequate about the PET scan facilities within the network because of something particular to her condition. I mean,
Is there a difference in PET scans?
there may, well, that I don't know.
I don't think so. You said someone advised her to go to Sloan.
Excuse me?
You said someone advised her to go to Sloan. Who advised her to go to?
The doctor.
Her physician did it.
I don't know if it was the Sloan physician or if it were a primary oncologist. I'm not sure who did this. I'm just sort of, I'm kind of happened and I don't know all of the facts, unfortunately. But from what I do understand, that medical provider said go to Sloan for the PET scan. Sloan said they want her to have the PET scan at Sloan because they're going to be reading the result. Yet the insurer said no, even though they approved Sloan before for this second opinion, now they're saying no.
Well,
You probably should just work with the provider and have them send the results for a second read at Sloan. If they're not getting a good print, and you don't think they can interpret it, then that's an argument that you can make. And look at the price differential. Probably Sloan will help you with that. They'll say, have it done there in Jersey and let them get a test for a second read. They'll send it overnight to Sloan. Sloan will read it and they'll say it's not good enough, and you'll have the argument to go to Sloan.
Okay.
but there is this issue about the magic of Sloan, or it's not just Sloan. I mean, you know, there is a lot of belief out there. There are certain places or the only places to get treatment for certain conditions, and it's not really always true. And it's, I think, those are among the most difficult disputes to have with the plan.
To add to the Sloan Kettering thing, they may have, and I don't know if you guys have encountered this in your CAT scans or PET scans, where they have different calibrations in some of the tests. And maybe if you can prove that the sensitivity of the test of the PET scan at Sloan is known to be far superior to that of whatever the hospital they were providing in New Jersey or wherever, we may be able to, on a technical piece of the equipment, to maybe pursue that and say, you know, their sensitivity and the way they have it calibrated is different from the standard in a different hospital. I don't know if
That might
that's-
give you the argument that it's not appropriate at this other place because it's not sufficiently sensitive for a particular purpose. That's a pretty, I mean,
Thank you.
it may be a particular circumstance that justifies that, but it may also be.
And Sloan can probably help you make that argument. They're active enough.
Yeah.
Have you had any cases with genetic testing, like denial because the BRCA wanted to test it? Because there's laws,
Denial of being
like on
insured.
coverage, yeah.
Yeah.
Because of-
No, in part because in New York, certainly, nobody can be denied based on any health characteristic. As a matter of federal law, everywhere in the country, if you come into a group under HIPAA, you cannot be denied coverage based on any health characteristic. In New York, in addition, buying individual coverage, you cannot be denied coverage based on any individual health characteristics. So it's possible that somebody might use that kind of testing in the context of buying individual life or disability coverage, but I haven't encountered it. And in health, it just, there's no circumstance in New York where anyone can do what they call medical underwriting, so that's it's not irrelevant.
Okay, I think it's more of like, this doctor's still advised to do it anonymously, I think, so I've heard of that, but you haven't encountered it.
In the interest of time, I'm just going to stop us here and we'll move on to Arnie's piece.